This is a part heard appeal in the matter of Gibson and TSE Malta.
Morning.
Morning, my lord. My lord, before I start on ground 3, yesterday in argument, your lordships asked me a number of times whether particular points had been put to witnesses.
Yes.
And I gave you a very unspecific yes without giving details. Now, overnight, my Lord Junior's produced a note which on the left side has your lordship's question, the bench's question, and on the right references.
This is the...
I don't believe it's been handed up yet, my lord. Mr. Mitchell's about to hand it up to... My lord, I wasn't proposing to go through those now, but it was more just that I was conscious that I hadn't responded to some of the questions being asked with any detail. In respect of the last of those, there was a question as to whether the RGI call we heard was atypical or representative. The last entry deals with that, and I'm told by Mr. Mitchell that was the only RGI call that was disclosed.
Only RGI call
that was disclosed.
It was disclosed. So do we know why others weren't disclosed? Were they just not available, or not fresh for them?
My lord, perhaps my junior might explain.
My lord, the understanding, at least on our side, is that the two other RGI calls were done by Mr. Rourke from the VIP team, perhaps from his work mobile phone, which wasn't recorded through the same system as calls that were handled by the help desk. And certainly our understanding was that that's why they're not available. But the full list of RGI interventions is in this hand-up. So one can see every time he was sent an email or a phone call, it's in that list. So if your lordships look at that, it gives you the full record.
Right, yes.
On ground 3. The question on ground 3 is whether section 33 of the Gambling Act has the effect that gambling contracts concluded whether betting exchange or operator is in breach of its licensing conditions are void or not. Now, in the judgment at paragraph 181, his lordship held that section 33 does not ban gambling as an activity and cannot have been intended by Parliament to operate so as to void contracts. And his lordship's reasoning was that section 33 did not imply a prohibition on gambling where performance would amount to commission of a criminal offence. And we submit that reasoning is wrong. Now, the question of whether gambling contracts in breach of the LCCP are impliedly prohibited will depend upon a consideration of the language in the statute, in consideration alongside questions of public policy, with a view to the mischief that the statute is designed to prevent. And to that extent, in terms of the law, there's not a great deal between the parties that we both refer to. I'm going to show your lordships cases that both parties refer to. They say largely the same thing. The first case, my lords, is Phoenix Insurance.
Can we have a look at section 33?
Yes, my lord.
I know we looked at it yesterday. It would be helpful to look at it again. It's in bundle 1, is it?
It is bundle 1 behind tab 1, page 22.
Yeah. It might be sensible to have that.
So my lord, section 33 makes it a criminal offence to provide facilities for gambling unless the provider holds a licence and acts in accordance with the terms of the licence. And the terms of the licence will include the social responsibility provisions of the LCCP. It's not all of the LCCP, it's just the social responsibility provisions of that.
What happens if you're right and the contract is void? then the protections that would, I mean, it all depends on the facts, of course, but, you know, protections available to the punter, to the customer, would be taken away, wouldn't they? And we'd be going back to the bad old days when gambling was illegal, or gambling contracts were void.
Well, my lord,
You couldn't enforce them.
So my lord, the premise here is that the gambling company has enabled a contract that it shouldn't have. It is a contract that is entered into in breach of its social responsibility obligations. So perhaps just to show you that provision, it's section 8.
If the position were at the end of a particular period of time that the customer was in credit, as it were, if you're right, the contract's void, the exchange could renege on the contract on the basis that it was void and that the customer wasn't entitled to recover.
Yes, so it's one of, you don't get your winnings and you don't make any losses.
It's a pretty odd way of protecting customers, isn't it?
Well, my lord, I'm going to submit that it's not. It gives effect to exactly what the Gambling Act is intending to do. So my lord, if I...
Okay, anyway, right.
So what one has to look at from the two authorities is the language, and we're looking now at the language of section 33.
You're going to show us Phoenix.
I was going to show you Phoenix, my lord. So if we go to A1, it's tab 10,
Yeah.
page 227, and the relevant part is at page 284. Opus, page 58. And my lord, you'll see a highlighted section. I just invite you to read that yourselves. My lord, in that section, you see at page 285, Lord Justice Carr considered significant that in that case the statute didn't merely render the effecting of contracts as prohibited, but the carrying out or performance of such contracts as prohibited. And his lordship held that that pointed to contracts made without authorisation being prohibited by necessary implication and void. If the contract is expressly or impliedly prohibited, then it's void. And Phoenix says that earlier on at page 279. And one can pick it up at just after the end of the highlighted section under B, the next point.
Sorry.
So where Lord Justice Carr says the next point is then that it's settled by law that any contract.
Sorry, which page are we on?
Sorry, 279, my lord.
So you're on there, okay. It's Cope and Rowlands, yeah.
Yes, it was Cope and Rowlands and Cornelius and Phillips. Too. And the authority referred to by my learned friends, with which I have no issue, is Ocadina and Chicale, which is at bundle A2, part 2, tab 31.
Yes.
And it's page 998 of the bundle. highlighted sections. So section 16 and 17 make the point that the question whether a statute has the effect of prohibiting the making of a contract depends on its construction. The language illegal and forbidden is used in a synonymous fashion. Over the page, paragraph 19, the fact that more commonly statutes tend to contain no express prohibition, which is why one then needs to look for an implication, and it needs to be a clear implication in paragraph 20. And the quote from Mr. Justice Devlin in St John Shipping Corporation, I submit has resonance here, where his lordship says in that case, if a contract has its own object, the doing of the very act which the statute prohibits, it can be argued you can hardly make sense of a statute which forbids an act and yet permits to be made a contract to do it, and that is a clear implication. Now, I would adopt that reasoning, my lords, and submit that in the present case, section 33 cannot sensibly intend to prohibit or seemingly create an offence out of facilitating facilitation of gambling contracts in breach of the LCCP, yet permit exactly such contracts to be entered into. And then paragraph 21 and 22 lift from the passage we just saw in Phoenix Insurance.
Well, Hughes and Asset Managers, which is cited at paragraph 23, is very much against you, isn't it? Because that's picking up the point I was making. Court held, top of page 1001 in this report, court held that the public interest did not require the court to construe the statute as rendering contracts made with an unauthorised dealer a nullity, sufficiently vindicated by the criminal sanction. So it's a very similar situation where there's a stockbroker who was trading without a licence, which was a criminal offence, but it didn't mean that the contract that was made with him was void.
So your lordship's right. That is a relevant part of the public policy, and in Phoenix, Lord Justice Carr distinguished between those contracts where if you render the contract void, you are undermining the protection that's to be afforded to the person for whom the policy is created.
And given how extensive the Gambling Act is, we might have expected that if it were intended that if correct construction was that section 33 rendered contracts of gambling void or nullity, the statute would say so.
My Lord, I submit this isn't like one of those cases where there is a public policy. There's a positive public policy to keeping that contract alive. It's not like there's food legislation cases where one might say that the person on the receiving end of food produced in breach of food safety legislation would be robbed of a remedy. These are cases where, my lords, the contract shouldn't have been entered into. I submit I'm going to show your lordship some other provisions in the Gambling Act to make good my point. So my lords, pre-Gambling Act, betting of all kinds was illegal, and gambling contracts were void. And the policy behind that was to protect members of the public from what was then viewed as a damaging activity. Now, that thinking evolved over time, and the Act provided a regime by which commercial gambling contracts, if they met certain social responsibility obligations, would no longer be unlawful, solely by virtue of being gambling contracts. Private gaming contracts became permissible. And that is, just for your note, it's section 296 of the Gambling Act, which is bundle A1, page 89. So private gambling became fine, whereas previously it was not. For commercial gambling, requirements were put down, and one of those, section 82, was a mandatory requirement that, so my lords, if one goes to section 82, it's in bundle A11, page 55, and it made it a mandatory requirement that operating licenses shall be subject to the condition that the licensee ensures compliance with any relevant social responsibility provision of the Code of Practice. It's not all of the Code of Practice, it's just that social responsibility provision.
Yeah.
And so, my lords, what the Act did was permit private gambling and permit commercial gambling subject to certain conditions. If one looks at the white paper that was issued...
Well, just before you do that, can I just ask you about something that's puzzling me at the moment, and go back to section 33, which is the starting point, which is what provides for what amounts to an offence. And it's providing facilities for gambling,
Yes.
unless in relation to a particular activity, A, you hold an operating licence, and B, the activity is carried out in accordance with the terms and the conditions of the licence. Now, suppose, to take for the moment an extreme example, that a betting intermediary has no codes of practice at all, which would comply with its social responsibility requirements of the licence. It would follow, wouldn't it, that providing betting facilities to anyone would be a criminal offence.
Yes.
And the same would be true, wouldn't it, if it did have some codes, but they fell short of what was required by the social responsibility requirements of the licence.
Yes.
So does it follow from your argument that if I go into my local bookmaker and I put a bet on the Grand National, and I'm not a problem gambler, assume, and the horse comes romping home, then the bookmaker could say, well, I'm not obliged to pay you your winnings, because as it happens, that there is a slight deficiency in one of the aspects of my code which deals with problem gamblers. Is that the consequence of your argument?
My lord, I'm hoping that's not the consequence of my argument.
If not, why not?
It must be, mustn't it?
Well, my lord, I submit that I'll have to think about it.
Objectively, they're not complying with the code.
Well, so my lord, it is. Well, your lordship is, I respectfully suggest, taking an extreme example at the periphery, and at that periphery, yes, I'd be.
That's how one tests.
I understand, my lord. I understand, my lord. But if I would have to acknowledge that if a no, I don't have to acknowledge apparently. So,
No, apparently you don't know the answer is.
My lords, perhaps if I could have a little, I will think about your lordship's question, and I will come back to you. In the meantime, my lords, if I show you some other provisions of the Act. So,
What are you going to show us?
so I was going to first of all, I was going to show your lordships the white paper that led to the Act.
Yeah.
And it's in Bundle A3, Part 2, tab 49. Paragraph, so if one goes then to page 1542. So in terms of this sets out the new legislative framework that was intended, and at the end of paragraph 2.3 on that page, one sees.
I think we need to get it on screen. I don't think it's across.
Sorry, again, on the screen, it is at tab 49, page 8.
Yeah.
And the last sentence refers to. So there was an intention, my lords, that yes, the law was changing. Gambling was not going to be ipso facto unlawful anymore, but what was intended was to carve out from that previous position. And if one then goes, my lords, to the explanatory notes to the Gambling Act, so one can put away A3 for the time being. It's A1, tab 2, which you don't have, sorry, page 98. And under summary of the Act, so for opus, that's under summary of the Act, paragraph 6, statement that gambling will be unlawful unless permitted by measures in the Act. So the default position is intended to be that gambling remains unlawful unless it falls within one of the allowable parts of the Act. So private gambling is now fine. Commercial gambling, as long as it's commercial operators offering gambling services, as long as they do so within the strictures required by the Act, it's also fine. Now, Section 334 repealed the old Acts. So I'll show you that one. It was A1, page 94. So the old days where all kinds of gambling, private and commercial, being illegal, those days were swept away to allow for the new regime. And then Section 335, for opus, sorry, we're at page 94. 335 subpara 1 now makes it clear that the fact a contract relates to gambling doesn't prevent its enforcement. Then 3352 says subsection 1 is without prejudice to any rule of law preventing the enforcement of a contract on the grounds of unlawfulness, other than a rule relating specifically to gambling. Now, it's worth seeing what the explanatory notes say on section 335, and one finds those in A1, page 111. And it says, in respect of 335, the section provides contracts to be capable of being enforced. This does not, however, override any other rule of law that prevents enforcement on the grounds of unlawfulness. Therefore, gambling contracts may be void on the same basis as any other contract. For example, among other things, illegality. So that then raises a question as to whether a contract entered into in breach of the codes of practice, the social responsibility parts of the codes of practice, would be unlawful, would be illegal. Now, I submit they would be on the basis of section 33, the breach of the...
Well, section 3352 is talking about a rule of law other than a rule relating specifically to gambling, isn't it?
Yes.
A reference to mistake, for example. But surely what that suggests is that unlawfulness, which would otherwise relate to gambling, doesn't render a contract void.
Yes, so if, for example, the mere fact of your contract being a gambling contract or relating to gambling will no longer render the contract void. Mm. But if you breach certain statutory provisions, that may render your contract void. And the question that arises is whether, I submit the question that arises, is whether breaching the LCCP provisions would be the kind of breach that would render the contract unlawful. And I submit it would on the construction of section 33. And also, the authors of Chitty have written a passage on this that also, in my submission, supports that analysis.
But does it follow that the final words of para 3352 are on your submission superfluous and should be struck out? Say that 3351 says shan't prevent its enforcement, and 2 should just say without prejudice to any rule of law preventing the enforcement of a contract on the grounds of unlawfulness, brackets, whether or not a rule relating specifically to gambling, so as to make sure that section 33 is
Cool.
So, my lord, I submit that the words in brackets are a sort of a for the avoidance of doubt provision in there. I'd submit that one doesn't need them because of subparagraph 1 of section 335. A contract relating to gambling is not ipso facto unlawful anymore. So there will be no rules relating to gambling specifically perhaps outside this act. So, my lords, if I take you to what the authors of Chitty say on this provision.
Well, it may be unlawful in the sense of involving the commission of a criminal offence, but what 3351 says is that shan't prevent its enforcement. And then you have to
Well, that's
come within the carve out in two.
I mean, a
Isn't that the
rule of
problem?
law relating specifically to gambling might be thought to refer, amongst other things, to an operator operating without a licence, which would be unlawful.
My lords,
I mean, I would have thought this provision is intended to protect members of the public, not take away their rights in the very circumstances in which the gambling company has failed to comply with its operator's licence. That's a very strange scenario. Anyway, that's your submission.
well, my
You're
lords,
going to show us Chitty.
I'm going to show you Chitty, my lord, just
Where's
to
that?
try to reinforce my submission. So it's Authorities Bundle A3, second part, tab 44. Page 1500.
Right.
And it starts at paragraph 4417, where they deal with it. The question, one I posited now, my lords, is the first question that arises from subsection 2 is its effect on cases in which the unlawfulness is due to failure to comply with other provisions of the Act, such as its licensing requirements. And then the in one sense relates to the view that your lordships were discussing.
No, you haven't included the rest of that.
Yes, but the last page inexplicably seems to have been cut off midway.
Yeah, but he's qualifying what he's saying there.
Yes. So, Mallow will.
But the focus at the bottom of the page is on the person guilty of the illegality, not
Yeah,
being able to
precisely.
enforce the contract. But that's
And
not
the
how a
word
contract
while
void ab
suggests
initio works. Illegality prevents either party enforcing it.
The word while suggests that Professor Davis then qualifies what he says in relation to the person who isn't guilty of illegality. So,
My lords, the point remains good that a breach of the provisions of the code should fall within the kinds of breach that would give rise to illegality. And in my submission, it's consistent with the proposition that contracts entered into in breach of the LCCP should be void. I submit from a policy point of view, what was the old default position before the Gambling Act 2005? Gambling contracts are void. That should remain. So if contracts are entered into in breach of the minimum requirements that the Act lays down for commercial operators to provide gambling services. If those services are provided in breach of the limited regime that makes them permissible, I submit that it is fair for those to be void. So fundamentally, the notion that gambling can be harmful to some people hasn't really changed. And what the Gambling Act 2005 does is to try to strike a balance between allowing gambling to carry on as a profitable activity which doesn't harm the majority of people, while protecting against services that may harm some.
What has changed, hasn't it, is that gambling is now recognised as something which can legitimately be regarded as conferring benefits on people, so that they should be able to enforce wagering contracts in circumstances where they previously couldn't. So focusing on the protection side of it is only looking at one side of the equation.
But the danger of not, my lord, is that one then sort of ends up in a position where the contract remains binding, remains a live contract for both parties. Now, I take your lordship's position that, at the moment at least, in argument, I can see your lordship's position that there may be situations where a vulnerable person manages to enter into a gambling contract that they should not have entered into. They make a winning. Is it fair that they be deprived of that winning?
Yeah, my point's wider than that. Leave aside a vulnerable person, someone who isn't vulnerable. But if there's a breach of the code, then I think on your case, can't collect the winnings.
Goes back to my lord's example.
Yes.
The person who isn't in any sense vulnerable or a problem gambler.
Well,
Who's faced with the bookmaker who says, "Well, I'm terribly sorry, but I'm not complying with my code, so you can't have your money."
Well, as a sort of public policy analysis, my lord, I mean, one could have so where perhaps let me park that for a moment. Let me come back to that point in a moment. So my lord, there's when one is looking at the policy aspect, there is so what often happens when regulators suggest they're going to regulate more strictly. Large betting companies will often say, well, if you do that, you're going to push our customers into the arms of unscrupulous foreign companies that don't subscribe to our rules, and that you're going to make the position worse. Now, those unscrupulous foreign betting companies, in my submission, provide a further policy reason why it makes sense for those contracts, for the contracts entered into in breach of the LCCP, to be void, because those contracts entered into with those foreign unscrupulous companies are contracts where the regulator will not really have any effective oversight or ability to regulate the individual. So you end up with a contract that is prima facie binding, but in circumstances where the person on the other end can act to some extent with impunity. Whereas, my lords, if the contract was void, that would not be the case. So in my submission, in circumstances where these are fundamentally contracts that should not have been entered into, then the fairest outcome is that they are voided. Now, my lords, before I end my submission on section 3.3, obviously on ground 3, the judge, at first instance, relied on section 336 in support of his conclusion that contracts in breach were not void. That's paragraph 179 of the judgment. I submit, my lords, that that is a different, section 336 is aimed at a different mischief. It is not aimed at the problem gambling mischief of our case. His lordship's point at 179 seemed to be that the fact that a power for the Gambling Commission to void an unfair bet existed, that power undermined any suggestion that contracts in breach of the LCCP were intended to be void. So, but my lords, I submit that the section 336 duty relates to invalidating an otherwise compliant, in quotes, contract, a contract that meets its LCCP obligations. As Lord Justice Popplewell identified in submissions yesterday, the criteria taken into account to establish whether something is substantially unfair don't overlap with the present case. So in my submission, section 336 should have been irrelevant to the inquiry. And just on that, so far as it's helpful, the explanatory notes on section 336 are in bundle A1, page 112. And in my submission, they support the proposition that section 336 is aimed at a different mischief. So my lords, I submit the reliance on section 336 was beside the point to the ground 3 issue. So my lords, those are going to be my submissions on ground 3 and my submissions first time around. On my learned friends have made some submissions on contributory negligence and limitation in the event the appeal succeeds. On those, I'm going to refer your lordships to our skeleton, paragraphs 58 and 59.
That's helpful. Thank you very much.
My lords, for all the reasons the judge gave in his judgment, the appeal should be dismissed. My learned junior, Miss Tulip, and I have agreed a split of responsibilities for oral submissions.
Okay.
Miss Junior, I'm going to open our response to the appeal with some introductory points, and Miss Tulip, not Miss Junior, will then deal with ground of appeal 1, and I will then deal with grounds of appeal 2 and 3.
Okay.
I want to deal with 2 topics by way of introductory remarks. I'm going to start by saying something about the context of this appeal and the deference which should be paid to the judge's findings. What this appeal is not is a rehearing. Nor, and I put this in parenthesis, is it an inquiry into how to fix the societal phenomenon of problem gambling. That is a matter for the regulator and ultimately for Parliament. So what this appeal is an inquiry into whether or not the judge erred to the applicable extent in the application of well-established principles of private law to the detailed, factual circumstances of one particular relationship between my clients, Betfair, and their customer, Mr. Gibson. And those detailed, factual circumstances were investigated at length over a 10-day trial. It was, in fact, originally timetabled as a 3-week trial. It was squeezed into 10 court days at the request of the judge by sitting longer days.
Right.
During the trial, the judge reviewed hundreds of documents. He heard evidence from 11 factual witnesses. Mr. Gibson, 9 witnesses from Betfair, 1 witness from BetDAC, our principal competitor, who gave evidence about BetDAC's liquidity. He also heard expert evidence from 2 expert psychiatrists and 2 experts in the betting industry. Both the betting industry experts agreed that Betfair's policies and procedures were, quotes, industry leading, close quotes, and quotes, ahead of the game. And just for your reference, you'll find those in Supplemental Bundle 1 at page 376, and the agreement from the other side at page 378. Mr. Gibson's betting industry expert had, however, submitted a report in which he asserted various breaches of the LCCP by my clients, all of which assertions were withdrawn by Mr. Gibson's expert in his cross-examination. As the judge says at paragraph 13 of his judgment, he doesn't refer to every aspect of the evidence or the arguments, but he had them in mind. That's what he confirms. In other words, the judge was, in the well-known phrase, immersed in the sea of evidence. The judge formed the view that Betfair's witnesses were reliable and that Ms. Lawson and Mr. Rourke were particularly, quotes, impressive. Yeah. By contrast, he formed the view that Mr. Gibson was an unreliable witness, and at paragraphs 16 and 17, he explained that he found that his witness statement contained evidence which was untrue, that Mr. Gibson had made serious allegations against others which were untrue, and that he'd lied to Betfair during the litigation, I emphasise, about the extent of his post-Betfair gambling. But those examples in paragraphs 16 and 17 were only examples. The judgment is in fact full of findings where the judge found Mr. Gibson's evidence was not reliable. Because the judge was immersed in the sea of evidence, because he was able to form views on the credibility of the witnesses he heard, the judge was uniquely well placed to look at the picture as a whole. And if I may respectfully say so, one of the key flaws in my learned friend's approach on this appeal is that it doesn't look at the picture as a whole. It focuses on isolated matters.
Well, that's island hopping, isn't it?
It's island hopping. Exactly, my lord.
Because unless you look at everything, you get a distorted picture.
Snippet of transcript of cross-examination here, a recording of an RGI there. But you get the distorted picture, my lord, I absolutely agree. And what you are in fact being invited to do is to substitute different findings and evaluations to the ones the judge made without having been shown that the picture the judge formed of the whole, the picture he formed of Mr. Gibson's conduct and the way he presented matters to Betfair was a picture that no reasonable judge could have arrived at. And on that basis, the exercise is island hopping. And on the authorities, it's an impermissible exercise. I just want to focus on two aspects of looking at the picture as a whole.
Yeah.
The first is that at all times material to the relationship, Mr. Gibson was a man of some considerable wealth. By 2015, he had 18 properties in total. That is a portfolio of 16 buy-to-let properties, a home in Yorkshire, and a home or an apartment in Mallorca. Of course, those properties were mortgaged, but after taking account of the mortgage debt, Mr. Gibson's net equity by the end of 2016 was, quotes, close to £2 million, as he accepted in cross-examination, and he had an income, an annual income in the hundreds of thousands. And I can just show you that in Supplemental Bundle 2 at pages forgive me, 466 and 467. 466, could I ask you to start reading at line 13?
Which bundle are we in?
Sorry, the opus reference is SB6, tab 1, pages 84 to 85.
Okay, let's just wait for those to come up on the screen.
So if we pick it up at line 13, can I just ask you to read from line 13 on the top page down to line 4 on the next page, please? So that was the picture by the end of 2016. Now, by the middle of 2018, Mr. Gibson had sold 4 of his 16 rental properties, but he remained a man of considerable wealth and his net equity remained broadly the same. One can see that if you look in the supplemental bundle 4 at page 104, which is FSB tab 23, tab 1 on Opus. This is an Excel table which was one of the documents Mr. Gibson provided to Betfair in the middle of 2018 to show the value of his portfolio. That's his buy-to-let portfolio.
So sorry, which page are we on in the bundle?
Page 104, please. It actually appears in the top, it's tab 23, it appears in the top right-hand corner.
Sorry, supplemental bundle 4.
Supplemental bundle.
Starts for me at page
It's the further supplemental bundle.
1 tab 4. That's
I'm
the
sorry,
one.
because
Yeah,
previously
it's-
it did seem to be
I know it's
supplemental bundle 2 was my supplemental bundle 2 for your last reference.
I do
So where we get the
Don't worry, I'll get there.
So further supplemental bundle.
Further supplemental.
Oh, look further. supplemental.
Can I?
Sorry.
Could we?
Further supplemental.
Yeah, the bundle references are not brilliant.
They are not, and I apologise. It's not. I think that is the fault of the parties collectively. It's a collective apology I'm offering.
Yeah. So page 104.
It's a spreadsheet. That's a good start. It's a spreadsheet. It's a spreadsheet that was prepared by Mr. Gibson and given to my clients. It addresses 13 of the buy-to-let properties. You can see they're identified by initials in the left-hand column where it says house and then various initials. There's a column in the middle. There's a column marked value about 5 along from the left. And although that doesn't have a total at the bottom, the total of these 13 alone was 4.5 million. The next column shows mortgage of 2.6, and the next column shows the equity, again, just for these 13, of 1.89 billion.
And an annual
income from renting them out at 271,000.
Absolutely, my lord, yes. Now, it is true that one of these properties was one of the properties sold in January 2018, but even allowing for that, the net equity is 1.75 million. And Mr. Gibson still had his home and his home in Mallorca. So his position remained broadly the same. Now, my learned friends say that's a fortuity because property prices were rising during the relevant period, but it's still a fact. At all times, he remained a man of considerable wealth, net assets, with considerable annual income. He chose to spend some, I emphasise the word some, of his wealth on gambling. Not how everybody chooses to spend their money, but he did, and there's absolutely nothing wrong with that. That was his prerogative.
Well, there's a striking sentence at the end of paragraph 109 of the judgment, where the judge says, indeed, even after the trial, there is no real suggestion that Mr. Gibson could not afford his gambling.
Absolutely. Absolutely. So what it in fact comes down to on this appeal is that by the word affordable, you have to construe that as meaning simply out of annual income, although even his annual income was considerable.
Yeah.
But there's absolutely no reason why you should do that. Affordability is a function of assets plus income. That was the first aspect.
If you were so rich that you had so much capital that you didn't need to work, it would be nonsensical to say you couldn't afford your gambling because you didn't have an income.
Absolutely. Absolutely. So, my lord, that was just the first aspect of the picture as a whole I wanted to touch on. The second aspect of the judge's ability to look at the picture as a whole is closely related. And it is that the judge makes the key findings that you're already so familiar with about the way Mr. Gibson presented matters to us. He presented himself and his finances in documentary evidence, but also through his regular interaction with Mr. Rourke, who formed positive impressions of Mr. Gibson and that he was happy with what he was doing. Now, the judge's key findings on this point are in three places. They're in paragraph 15, right at the start of the judgment. And that's where I'm going to start. But for your notes, they're also at paragraph 129 and 164. Ms. Tulip is going to deal with the detail when she comes on to dealing with ground of appeal 1 and the idea that Betfair the judge is finding there was no basis for saying that Betfair ought to have known that he was a problem gambler. But I just want to emphasise the significance of, for example, what's in paragraph 15. So if we pick it up in the third line, at no point did Mr. Gibson tell Betfair he had a gambling issue. And then in the next line, on the contrary, he assured Betfair at every turn that he was comfortable with his gambling and could afford his losses. And there was an occasion when he referred to himself as a multimillionaire. And then the judge turns to the financial documents. If we pick it up in the middle, he had passed every money laundering inquiry and makes no complaint about Betfair's approach to that. There is no real suggestion that the vast amount of financial information he provided to Betfair was materially inaccurate. He felt some of it might have been exaggerated by him. There was therefore nothing objectively concerning about the level of the losses. Although they were large, they appeared sustainable. Now, in my respectful submission, jumping ahead to negligence, leave aside duty of care, that would be a complete answer to breach. Because if that picture that was being painted were not an accurate picture, Mr. Gibson would have been misleading us. There is one respect in which it's clear Mr. Gibson did mislead us. The judge finds as a fact that throughout the period he had a moderate gambling disorder. And that is the basis for the judge's finding, I suggest, in paragraph 129, that Mr. Gibson misled us. You just turn that up.
Yeah.
And painted a wholly inaccurate picture. But that was the only respect in which the picture being painted was actually inaccurate, because when it came to his finances, he was giving us, my respectful submission, an accurate presentation, and the picture was that he could afford what he was doing.
Yeah.
Unlike the judge, this court is not immersed in that sea of evidence, and in my respectful submission, you should allow yourselves to be guided by the judge's key findings at para 15, 129, and also at 164 to similar effect, which have not really been challenged, save as to a debate about what affordability means, and which have certainly not been shown to be findings that no reasonable judge could have come to on the evidence presented to him. That was the first introductory topic that I wanted to deal with, about the context. The second topic I wanted to deal with is quite different. I just want to say something about the concepts or the terms problem gambling, problem gambler, and gambling addiction. I'm going to start at the end of that with gambling addiction. A pathological gambling, I'm sorry, I may have misspoken there. When I said gambling addiction, can I scratch that? I meant gambling disorder. So the
Yes,
terms are
yes.
problem gambling, problem gambler, gambling disorder. A pathological gambling disorder, also known as a gambling addiction,
Yeah.
is a psychiatric condition. Gambling disorders lie on a spectrum. You can have a mild disorder, a moderate disorder, or a severe disorder. There are different ways to screen for gambling disorders, but both the expert psychiatrists who gave evidence regarded the DSM-5 screening criteria as the appropriate set to use. In the supplemental bundle, the further
DSM-5, which you handed in yesterday.
it was handed up yesterday. Can I take you to the further supplemental bundle?
Yeah.
For my information, do you have tabs in that bundle?
No.
No. Could I ask you then to turn to page 26,
26.
please?
Mm-hmm.
Is that the joint expert statement?
It is.
Bingo. Lord Justice Popplewell, have I lost you?
No,
No.
but I have looked at this, and this involves not a recitation of DSM-5, but a paraphrase of it in different terms by each of the experts. And I'm wondering whether, if you were going to use this as a shorthand, it is a useful shorthand, or whether we shouldn't just look at the
I'm very happy.
document itself that's been handed
Very,
up.
very happy to do that.
It struck me this isn't quite in the same terms.
Yes, very happy to do that. Right. The document that has been handed up compares in the left-hand, or sets out in the left-hand column DSM-4, and then it shows the changes in DSM-5. And essentially there were two changes between DSM-4 and 5. The first is that stealing or committing illegal acts had been removed as a screening criteria. So with DSM-4 there were 10 criteria, with DSM-5 there were 9.
Oh yeah, 8.
You can see that number 8. And the other difference is that the criteria have been reordered for some reason.
The numbering's been changed,
yes.
hasn't it?
But that having been said, I think you'll find it easier to read if we look at the left-hand column, the DSM-4
Yeah, I
column,
agree.
but recognising that the psychiatrists supplied DSM-5.
There's a difference in the criteria, but there's also a difference, isn't there, in the qualitative analysis. DSM-4 starts a day with persistent and recurrent, as indicated by 5 of the following, whereas DSM-5 talks about 4 or more within a 12-month period, and ends at over the next page at splitting it into mild, moderate and severe, according to whether it's 4 to 5, 6 to 7 or 8 to 9.
Yeah.
And am I right in thinking that wasn't in DSM-4, so that's a DSM-5?
You are right, my lord. In fact, I'm just rethinking on my feet. Let's look at the DSM-5 column, because that's the one that the psychiatrist supplied. So the first row, which is number 4 in DSM-5, but it's number 1 in DSM-4, is often preoccupied with gambling, having persistent thoughts of reliving past gambling exercises, handicapping or planning the next venture, thinking of ways to get money with which to gamble. What I'm going to do is I'm going to go through these and I'm going to identify the ones which are mental states. That's important. So that is a mental state. The second one, if we just look at the left-hand column, because it's the same, needs to gamble with increasing amounts of money in order to achieve the desired excitement. So that is a mental state. Subjective mental state. Third one, has repeated unsuccessful efforts to control, cut back or stop gambling. That's a fact, it's not a mental state, but in order to know it, you require information from the gambler. Fourth one, is restless or irritable when attempting to cut down or stop gambling. That's a mental state. Fifth one, gambles as a way of escaping from problems or of, looking at DSM-5, often gambles when feeling distressed, e.g. helpless, guilty, anxious. Okay, that's a mental state. 6, after losing money, gambling, often returns another day to get even, chasing one's losses. That's a mental state. 7, lies to family members. Well, that's a combination of fact, but
Well, six may be
Six may
something
also
you
be
can,
fact
you
related.
can, you can detect objectively.
well,
From
there may be
the
pointers
fact.
objectively, but in order to be satisfied that it's right, it's a question of the intention.
Yeah.
7, lies to family members. That's a mixture of fact and object and mental state. 8 was the one that was dropped. 9 has jeopardised or lost a significant relationship, job or education, or career. That's objective fact. 10 relies on others to provide money to relieve a desperate financial situation caused by gambling. Now, having gone through that list, what we see is that 6 of the 9 criteria are mental states, and the other 3 are not, but they require information from the patient or the gambler in order to know whether they're satisfied or not. And part of the case that Mr. Gibson ran at trial was that my client's Betfair knew or ought to have known that he likely had a gambling disorder. And there were formidable difficulties in the way of that claim. The first is that for 6 of the 9 criteria, you can't make any progress at all unless the gambler is prepared to tell you what was going on inside his head. And the second formidable difficulty is that you can't screen accurately using any of those 9 criteria if the gambler is not prepared to be truthful with you. And if you still have the further supplemental bundle, could I take you right to the start of it and to the cross-examination of Dr. Needham Bennett, the psychiatrist for Mr. Gibson, page 1.
Yeah.
That's not the document on the screen. It's the further supplemental bundle, tab 1, page 1, for Opus.
So this is page 3 of the bundle. Yes.
It's page 3 of the bundle. Thank you. And at line 13, I said, let's just start dealing with these at an abstract level. These were the DSM criteria, so not specifically in the context of Mr. Gibson. A number of these 9 criteria are in fact concerned with the individual's state of mind or mental state, correct? Yes, probably most. Yes, well, I was going to suggest 6 of them, so, and then we ran through them, just as I've run through them with you now. And Dr. Needham Bennett agreed, although the numbering there is the numbering set out in the joint expert report. Yeah. And then I said, so that's 6 out of the 9. In order to diagnose whether or not those criteria are present or were present at the relevant time in the individual, you have to speak to the individual to understand what was going on inside their head. Yes. And then if we turn forward in this bundle to page 11, at line 18,
yeah.
Do my lords have page 11? At line 18, it says, can we agree, I said, can we agree this? You can't diagnose a gambling disorder by reference to data alone. And he said, I agree. And then if we turn forward to page 14 to 15, sorry, 14 actually, up at the top, I said, and we've agreed it's very difficult to detect when someone lies to you.
So where's that?
Page 14 of the bundle, my lord.
Oh yeah, got you. Yeah.
And we've agreed it's very difficult to detect when someone lies to you, yes. And you yourself, for example, have not been able to make any attempt in the drafting of your report of such an assessment of Mr. Gibson, yes. In the sense you've left the issues like that to the court to decide, yes. And you cannot form a view of any of the 6 subjective states, which is an accurate view, unless the person that you're talking to is someone who is telling you the truth, yes. So that's gambling disorder.
Yeah.
And I turn to
was Mr. Needham Bennett's diagnosis on the assumption, without testing it, that what he'd been told by Mr. Gibson was true? Was that the basis for his opinion?
Absolutely. So what had happened is Mr. Gibson had gone to Dr. Needham Bennett. They'd had an interview over a number of hours. Mr. Gibson had had narrated a version of events. I put it to Dr. Needham Bennett in cross-examination that it was a very carefully curated version, but Dr. Needham Bennett's report was entirely dependent on the gambler, in this case Mr. Gibson, having been prepared to tell him what had been going on in his mind.
But the judge's finding that he was in fact suffering from a gambling disorder must have taken as its premise that he was telling the truth, or at least mostly telling the truth to the psychiatrist.
That's right. Yeah. So, problem gambling and problem gamblers, but let's stick with problem gambling, signifies something different and lesser than gambling disorder. It follows that you can be a problem gambler, come back to what that means, without having a gambling disorder. It's like two circles on the Venn diagram. Problem gamblers, much smaller circle, gambling disorder. I suggest the best definition of problem gambling for our purposes is the one the judge offers at paragraph 120. Let me rephrase that, because on the what I meant to say was I suggest the best definition of problem gambling for our purposes is the one the judge offers at paragraph 120.
Yeah.
But what that definition doesn't tell you is how to identify who is or is not a problem gambler, because it doesn't tell you what degree of compromise, disruption or damage makes a problem gambler. Now for that purpose, although the LCCP use the term problem gambling, it doesn't define what that term means. There are two screening tools which have been used in different contexts for the purpose of identifying problem gamblers. Those are DSM-5 and the precursor DSM-4, which is used by medical practitioners.
Yeah.
The judge refers to that at paragraph 71 of his judgment. And also something known as the PGSI, which you were told about yesterday, the Problem Gambling Severity Index. And the judge deals with that at paragraph 61 of his judgment. And the PGSI operates by reference to a number of screening criteria. And I think I should suggest that, that they begin at Roman 1 and they go through to Roman 9. Roman 2, I need to gamble with increasing amounts of money. In fact, the criterion that's specified is I need to gamble with increasing amounts of money to get the same feeling of excitement. I have the PGSI questions here, if as a printout, if it would be helpful to have them. But if we go through this list of 9, essentially you get they're slightly different to the DSM criteria.
So who issues the PGSI?
What
does it come from?
I'm grateful to my friend Mr. Mitchell. It's a screening tool that was developed for population surveys in Canada, so it would have been a Canadian body. I'll take you, perhaps I should take you now, to in supplemental bundle 3, the page I want to go to is page 1404. An opus, that's SB7/1/8. No, sorry. SB7/1/1. No, you're quite right. You've got the right page. Thank you. Right. So in the hard copy, page 1404. So what this document is a document I think you were shown yesterday. It's the NatSen Gambling Behaviour in England and Scotland survey, produced in 2014. So up at the top of the page, it talks about using DSM-4 as the screening instrument for problem gambling. And then in the next bullet point, it talks about the PGSI being developed for use among general population and was tested and validated in Canada. The instrument consists of 9 items, and those are the 9 items set out in the judgment at paragraph 61. And then, under the heading Problem Gambling Prevalence Rates, it says, according to DSM-4, problem gambling prevalence rates among adults in England and Scotland was 0.5%. Next bullet, according to PGSI, problem gambling prevalence among adults in England and Wales was 0.4%. And then this is really important, the next bullet point. There is no gold standard or commonly accepted way to measure problem gambling in the population-based surveys. For this reason, surveys measuring gambling problems in Britain have tended to include 2 different instruments, as they capture a slightly different range of people and problems. It's therefore possible to produce a problem gambling estimate based on whether participants were categorised as problem gamblers according to either DSM-4 or PGSI. So there is no gold standard, no commonly accepted way of identifying a problem gambler. There are various...
Sorry to interrupt. Speaking for myself, I think I would quite like to see the PGSI, if we could at some stage. I find this a little bit confusing. The second bullet point suggests we've got 9 items.
With scores ranging from 0 to 27. Which suggests that...
Well, yes, one would have thought it would be.
Can I hand...
0, 1, 2, 3. Let me work. 0, 1, 2, 3.
This is an extract from the trial bundles, and my learner friends have a copy.
The suggestion, a score of 8 represents problem gambling. That's just, is that from the footnote just the view of the author of that paper?
Yes.
Or does that have some other imprimatur?
So if I think perhaps I skipped over the second bullet point too quickly, my lord. So the PGSI was developed in Canada. The instrument consists of 9 items, ranging from chasing losses to gambling causing health problems and feeling guilty. Each item is assessed on a 4-point scale. Never, sometimes, most of the time, almost always. So never gets 0, 1 gets sometimes, or sometimes gets 1. Exactly. Scores for each item are summed to give a total score ranging from 0 to 27. A score of 8 or more on the PGSI represents problem gambling. What I've handed up, just so that you can see the PGSI criteria on the left-hand side. The point of showing you this, if I may, is that if you look at these criteria, we see that just like the DSM criteria, although they're different, most of them depend on establishing a mental state, a subjective state of mind. And all of these criteria can only be used accurately if the person responding to the questions is prepared to be truthful. Now, the context in which the judge was looking at these criteria and referred to them at para 61 was Miss Lawson's cross-examination. And it was put to Miss Lawson that PGSI was what should have been being used by Betfair. But it's important to look at what the judge says about that at paragraph 62 of his judgment. He says it was suggested to Miss Lawson that these indicators would be a far more efficient way to identify a problem gambler than the methods set out in the Betfair responsible gambling policy. And the answer to the questions could be worked out for a particular customer. In the face of these criticisms, Miss Lawson's evidence was clear. She couldn't see how these criteria could be used in practice, and she was quite content with the systems Betfair was using, including the CAP system, which the judge has already referred to. So the idea that you could use PGSI in a practical context of an online gambling operation was roundly rejected. The judge found Miss Lawson to be an impressive witness, and he was perfectly entitled to accept that evidence. So the position is this, that it is very difficult to be precise about the criteria for who is and who is not a problem gambler.
I find this terribly confusing, this page, because it puts it, if I've read it right, it looks at the survey results and puts them into categories at the top of non-problem, low risk, moderate risk, and only problem gambler if you're of those who are achieving the scores on the far right-hand column. But if you look at moderate risk, there are significant numbers who are getting almost always gets you a 3. And most of the time gets you a 2. And yet those aren't reaching a total of 8. That's,
No.
I mean, I know I'm just trying to look at the statistics.
My lord, this comes from a document that was in the trial bundles. The whole document isn't in the appeal bundle. From memory, I just can't remember whether the document reveals anything more about the underlying statistics.
But was the score, I don't want to take any more time than is necessary, but trying to define problem gambler is perhaps quite important. Was the criterion of 8 taken from looking at the surveys, deciding which of those should be characterised as problem gamblers, and then seeing which of these characteristics they had and scored, and working back to 8 as the appropriate indicator? If not, how?
To the best of my information, my lord, the screening criteria were developed as a tool in Canada. The maximum score is 27. 8 was set as the system tops out. The PGSI system tops out at 8. So you for PGSI purposes, you either are or are not a problem gambler.
I understand that. It's who chose the 8 and how that I'm interested in. In terms of the who, it may be that was the authors of the survey document as a whole. In terms of the how, this document looks as though it's identified what it regards as problem gambling, and then seeing what people scored in relation to the answers to these questions, and then working out that if they got 8 or more, they fell into the. But I may be entirely wrong about that.
Yeah. My understanding, but I may be wrong about this too. My understanding is that the trigger point of 8 comes over from Canada, built into the criteria.
Right. But whether it was simply chosen,
I don't know.
No. Okay, thanks.
But just bringing it back to the point, if I may, of having taken you to this, the position is that it's very difficult to be precise about what criteria to use to identify a problem gambler. 2, there are real practical difficulties about any sort of diagnosis because you are dependent ultimately on the willingness and honesty of a potential problem gambler with whom you interact. And the absence of a definition from the LCCP is itself telling. Putting it at its lowest, the regulator might have been deliberately leaving the concepts fuzzy and grey. And in my respectful submission, in due course, this is ground appeal 2, in due course, I will be submitting that makes a very unpromising ground for the basis of a common law duty of care, with all the sledgehammer black and whiteness of a common law claim for damages. So my lords, unless I can help you further on that, we'll turn to ground of appeal 1 and Ms. Tulip will take over.
Right, thank you very much. Yeah. Yes, Ms. Tulip.
My learned friend recognised that it's necessary, though not sufficient, for him to succeed on ground 1 in order to succeed on this appeal. And in my submission, the judge's finding that Betfair was not in breach of the LCCP was clearly right. But I don't need to go that far because, as my learned friend also recognised yesterday, the question is whether the judge was wrong. And insofar as the judge proceeded on the basis of factual findings, the question is whether those findings were unsupported by the evidence, or they were findings that no reasonable judge could have found. And I say we're not in that territory, not even close. The structure of my submissions on ground one will be in three parts. Firstly, I want to look at what the relevant provision in the code, so SRC 3.4.1, actually required, and at the relevant time. Secondly, to address the so-called policy and procedure breaches, which were the breaches my learned friend, alleged breaches that my learned friend took you to yesterday afternoon. And then thirdly, I'm going to address the argument that Betfair was in breach of the LCCP by not closing the claimant's account sooner. And it's in this context that I will be addressing the judge's finding, which my learned friend characterised as incoherent, in relation to Betfair's actual constructive knowledge of problem gambling on the part of the claimant. So before we turn up SRC 3.4.1, the relevant provision, I do want to take you to two authorities on the question of how one construes a provision in a statutory code. And I do that for two reasons. Firstly, to be frank, because these authorities are not referred to in our skeleton argument. And secondly, and most importantly, because yesterday my learned friend referred to a number of external materials to aid his interpretation of SRC 3.4.1. Including Gambling Commission documentation, some of which postdates the period relevant to this claim, the National Health Survey, and even what one witness said in cross-examination in this case. I think before we go too far down that line, it's important to step back and consider, well, to what extent are external materials relevant to the matter of construction at all. So the two authorities I'd like to go to, the first of those is the decision of the Supreme Court in Lambeth London Borough Council and Secretary of State for Housing. This is at tab 53 of the authorities bundle, so AU 53 for Opus. And I think it will be in volume 3 of the authorities bundle.
Yeah.
So this was a case concerning the interpretation of a planning decision notice. And if we turn to page 10, the relevant paragraphs are in the judgment of Lord Conworth at paragraphs 15 to 19. If I could ask you to read those paragraphs, please. So the conclusion of paragraph 19 is that whatever the document is, whether it's a private document such as the contract or a public document, the starting point and usually the end point is to find the natural ordinary meaning of the words used, viewed in their context and in the light of common sense. But I do also emphasise the point made at paragraphs 17 and 18 by reference to the case of Trump International, that although there is not a complete bar on implying terms into conditions such as a planning permission, given the potential criminal sanctions arising from a breach of a planning condition, the court should exercise great restraint in doing so. And there's a clear analogy here because, as we've seen, breach of social responsibility code provision can give rise to a criminal sanction. Now, the approach of Lord Carnwath was applied more recently by the High Court in the case of Crown, GB News and Ofcom, which is behind tab 55. So it should be the same hard copy bundle, AU 55 and Opus. Now, in this case, Mrs. Justice Collins Rice was considering a challenge to Ofcom's interpretation of its broadcasting code. In circumstances where Ofcom had held that a Jacob Rees-Mogg State of the Nation broadcast contravened the code's provisions relating to news programmes and impartiality. And if we go to paragraph 46 of her judgment, which will be at page 15 for Opus, you can see that she's referred to what Lord Carnwath said in the Lambeth case, which we were just looking at. She then considers at paragraphs 47 to 49 the specific broadcasting code provisions relevant to that case. And if we turn over the page of paragraph 50, I'm going to invite your lordships to read paragraphs 53 to 52. So paragraph 50, she recognises the tension or the potential difficulty that arises when you have a regulator applying its own code of conduct. And she says, she asks rhetorically, and come to this a bit later in the judgment, well, in that context, where does applying the rules stop and changing them start? So if a regulator makes a certain decision or makes a certain pronouncement, are they applying the rules as they are, or are they actually changing them? And I emphasise paragraph 52, where she emphasises in terms of how you approach the issue of construction of a statutory code. The first question is to ask, well, is there any ambiguity at all? Because it's only if there is ambiguity, then you look further ahead. And if there is ambiguity, then what you do is you look to the statutory code as a whole. And it's only if, having looked at the code as a whole, that there is still ambiguity, that you might look further. And she refers to then looking at the parent statute and any wider historical or policy perspectives. Paragraph 6.
It's quite an unconventional approach to construction.
No.
Say you've got to find an ambiguity to start with. The approach tends to be more nuanced than that. That one's just trying to ascertain the meaning. And it's, I think there's been a move away from the historical tendency to start with a threshold of an ambiguity.
Yes, so I think the point the judge is making here is that it's just really important to start with the wording, and that the starting point, the wording might be the end point as well, but that's where our analysis should be grounded. And there's
he's saying, isn't he? So she's saying, and Lord Carnwath earlier, that you don't look beyond the code itself unless it's ambiguous.
Exactly.
So, and that's your point, really, isn't it? Your point is that unless the code's ambiguous, that all the other materials that we referred to are effectively inadmissible.
Yes, and
as aids to construction of the code.
aids to construction. And in relation to the specific question of guidance that might be issued by the regulator, if we go to paragraph 61 of the judgment, so this isn't marked up on the report.
61.
61. So this will be just over the page. And here she's referring to some guidance issued.
61 of the judgment we were in.
61 of the judgment we were in, yes. So I think it's
Sorry, we've
yes.
suddenly gone to the judge's judgment for some reason.
So it should be just over the page.
Yeah.
So she refers to some guidance by Mr. Kevin Backhurst. We know from earlier in the judgment that he is essentially a senior Ofcom person. And so he's written some guidance about how these code provisions that she's considering are to be construed. And she finds it helpful for illustrative purposes, but the point she emphasises that guidance of this sort is not an aid to the construction of a statute code. The interpretative hierarchy works the other way around. So it's for the court to determine what the code means and for the regulator to follow that. The court isn't bound by what the regulator says the code means. If we turn over to paragraph 86, this is skipping ahead a little bit. So paragraph 86 of the same judgment, so it's page 22 for Opus. So paragraph 86, the judge says she rejects Ofcom's alternative analysis, and she gives 5 reasons for that. I invite you to read paragraph 87, which is her first reason for rejecting Ofcom's analysis.
Yeah.
So again, this is the point we were just discussing earlier, and it would not to be controversial, but the point is that words matter, and we say that just as Ofcom must have been taken to have chosen the words in its broadcasting code with great care, so too the Gambling Commission must have been taken to choose the specific words in the licensing codes of conduct provision with great care. And then the final point is by reference to paragraphs 92 to 93. And if I can just summarise the point here, essentially one of Ofcom's arguments on this case was to say, well, it's all very good adopting that literal interpretation, but that doesn't allow us to deal with the new style of politician-led topical news, current affairs programmes. We have objectives, and essentially the wording of the code should be flexed to enable us as the regulator to meet those objectives. And the judge rejects that argument. And the reasons for that are explained over the page. So starting at paragraphs 94. But her essential point is that if the regulator wishes to change the rules, they should change the rules. And there's a process for consultation, just as there's a process for consultation if the Gambling Commission wishes to change its rules. And that is the correct approach. So I said I was going to take you to 2 cases. For completeness, I'm not going to take you to it, but I do want to mention the case of Ritz Hotel in Algiers. This predates both the Lambeth case and the GB News case, and it doesn't address the approach to construction of statutory codes in any particular detail. But it is a case concerning the LCCP, and in that case, Mrs. Justice Semler does make the point, 1, that it would be wrong to criminalise behaviour without clear words, and 2, that the construction of the LCCP is a matter for the courts, not for the regulator. Right. So the reference for that is paragraphs 129 and 130 of Ritz and Algiers, and it's at Authorities tab 25. So against that introduction, I'm now going to turn to how this applies to the proper interpretation of 3.4.1 in the code. And so for that, we need SB 338 for Opus. And I think for those using hard copy bundles, it's the first supplemental bundle. Tab 3 if you are lucky enough to have tabs, and page 122 for everyone else. So it is described as a social responsibility code provision, which means that it's a condition of the operator's licence, and breach of it may lead to criminal sanctions. I know we've looked at this already in some detail, but if I just read aloud the opening words. So licensees must put into effect policies and procedures for customer interaction when they have concerns that a customer's behaviour may indicate problem gambling. And it then it says these policies must include, and they are specified at subparagraphs A, through to F. Now, my learned friend's submission yesterday was that those opening words, in particular the phrase where they have concerns that a customer's behaviour may indicate problem gambling, were a threshold or a trigger that had to be passed before an operator was required to have and put into effect policies and procedures. And that led to the debate of, well, what is problem gambling, or what is a problem gambler? Now, in my submission, that's not the right way to look at it. And that's essentially because by seeing those words as having a precondition or as being a necessary trigger, the provision becomes circular. And you can see that because if you look at subparagraph B, this is what the policies must include. They must include, per B, the types of behaviour that will be logged reported that may trigger customer interaction. And in particular, by subparagraph E, your policies must include specific provision to use all relevant sources of information to ensure effective decision-making and guide deliver customer interactions, including, in particular, provision to identify at-risk customers. That is, customers who are at risk of having problems with their gambling.
Yeah.
And so the operators are required to have in their policies and procedures provisions to identify people who are at risk of having a problem with their gambling. And so it doesn't make sense to say that you only need to have policies and procedures if you have those concerns to start with, because the point is that your policies and procedures, one of those functions that they should be serving is help you to identify whether someone is a problem, whether someone is experiencing problem gambling at all. And so in my submission, the way to read those opening words is in a more general sense, that they're saying to the operator, you need to have policies and procedures, and they need to be about problem gambling, and this is what they must include. It's not a threshold condition that applies before you even get into the question of what those policies, whether you have to have policies at all. And the focus very much is on what the policies must include. And I say even if I'm wrong on that, even if there is some vague preliminary threshold requirement, the conclusion of that requirement is that, well, what you must have in that circumstances, policies that must include A through to E. And what's putting those policies into effect means is that it's not enough to just have a policy and put it in a drawer, you have to implement it. And as to what the content of those policies and procedures must be, well, 3.4.1 is, as the judge held, non-prescriptive. The claimants place particular emphasis on subparagraphs C and E, so your policies must include C, the circumstances in which consideration should be given to refusing service to customers or barring them from the operator's gambling premises. So it does not say what those circumstances or considerations should be. And as Lord Justice Flo, you pointed out yesterday morning, it doesn't say that you must refuse service. It says you have to have policies which set out the circumstances where you will consider refusing service. And the licensed operator is given the discretion to decide what those circumstances are. Now in subparagraph E, my learned friend emphasises the words to ensure effective decision making and to guide and deliver effective customer interactions. Now in my submission, what those words do is they go to the relevant sources of information, the purpose to which the relevant sources of information are to be put. And you can see, so it's not an obligation in subparagraph E to interact with a customer in a particular way, to have an effective customer interaction. You must have policies and procedures. They must include provision to help you identify at-risk customers. And the intention behind those policies must be to ensure effective decision-making and effective customer outcomes. And in this case, there can be no question that that's what Betfair's policies were aimed at doing, because the judge found as a finding of fact that Betfair's approach to compliance, this is paragraph 133 of his judgment, Betfair's approach to compliance was driven, in my view, by a desire to root out problem gamblers. So subject potentially to that qualification as to intention, as to the purpose of your policies, it's clear on its wording that subparagraph E is concerned with the content of an operator's policies and procedures. It doesn't tell the operator how to interact. does give them some guidance as to what their policies and procedures should include. And as to what those policies and procedures should include, it's non-prescriptive. So we can see from subparagraph I, you should make provision to identify at-risk customers, not problem gamblers, not persons with a gambling disorder, at-risk customers, another undefined term, who may not be displaying obvious signs of or overt behaviour associated with problem gambling. And it gives us examples, indicators such as time or money spent. So even those indicators are not prescribed, they're not required, they're examples. It doesn't tell the operator what the indicators should be, and it certainly doesn't say what threshold those indicators should be set at. Now the claimants say that 3.4.1 contains a de minimis requirement to refuse service to a customer who is or is likely to be, or perhaps even maybe, a problem gambler. And I say the rule just does not say that. And actually, yesterday morning, in response to a question from Lord Justice Popplewell, my learned friend said that he could or might relax his submission to say that actually it's a de minimis requirement of 3.4.1, that if an operator knows that someone is likely to be a problem gambler, then they should exclude or place a limit on the amount of a customer's gambling to ensure that they're gambling within their discretionary income. And to be clear, we say that 3.4.1 does not say that either. And in fact, the fact that it is said SOC 3.4.1 requires can change in the course of submissions, in my sense, shows that it's not grounded in a clear construction from the words, and it tells against it as a fair or proper construction of what it means. And that leads on to my next point, because although I do say that 3.4.1 is clear on its face, it admits of no ambiguity, we don't need to go any further. If we do go further and look at some wider considerations, then those support the construction that I adopt and that the judge adopted. And the first of those is criminal sanctions, which we've already seen from Lambeth is a relevant consideration. And so because breach of 3.4.1 gives rise to potential criminal sanctions under section 33, that's a reason to exercise particular caution and particular care as to what 3.4.1 means.
So is it your submission that if under C, the policy says we will never give consideration to refusing service, those are the circumstances, we don't think it will ever be appropriate to refuse service, that would be a compliant policy, and therefore there could never be a breach of the 3.4.1 in relation to anyone, however vulnerable.
I'm not sure I'd go quite that far. I think the fact that the rule says consideration to which should be, the circumstances in which consideration should be given, impliedly assumes that there are some circumstances in which refusal of service should be given. But beyond that, it is up to the operator to decide what those circumstances should be, and whether they set that as a high threshold, and so only be in extremely exceptional circumstances.
Only when a gambler has lost £20 million will we start to give any consideration to whether they should be excluded. That would be a compliant policy, and
Yes.
that's simply the
Yes,
very light regulation that's been set by this provision.
quite. And as we'll see, the regulator can and has changed the rules since this version of the provision, but looking at this at this point in time, yes, it's non-prescriptive, it's for the operator to decide. So as I said, in terms of widening out our factors, if there is any ambiguity here, the first point was criminal sanctions, and that tells against, that urges us to exercise particular restraint when construing the provision. The second factor is other provisions of the code at the time, because the GB News case tells us that in case of ambiguity, that's the next thing we do. And in this case, I would just like to invite you to read the provision about self-exclusion, which is at page 10, so over the page. 124 in the bundle. So we're in the same tab, it's 2 pages on. 3.5 self-exclusion. Yes. So this is the Social Responsibility Code which governs self-exclusion. 3.5 sub 1, licensees must have and put into effect procedures for self-exclusion. That all seems quite familiar. And take all reasonable steps to refuse service or otherwise prevent an individual who has entered a self-exclusion agreement from participating in gambling. And then sub 2 says that licensees must also, as soon as practicable, take all reasonable steps to prevent any marketing material being sent to a self-excluded customer. So this provision clearly goes beyond requiring operators to have policies and procedures in the context of self-exclusion, by contrast to the position in relation to customer interaction. You must take reasonable steps to refuse service in this scenario. There is no comparable provision in 3.4.1. And what this shows us is that where the Gambling Commission wished to prescribe a particular outcome, or to be more prescriptive, it did so. So I say that reinforces the judge's view and our submissions on what the proper meaning of 3.4.1 is. The third point is to look at the provisions of the code as they were later amended, because as we saw from the GB News case, it's relevant to take into account the fact that the regulator can amend the statutory code. And what's particularly telling in this case is that the Gambling Commission did amend the relevant provision of the code. And I think the easiest point to take this is from paragraphs 37 to 38 of the judgment. So if we could have core bundle, tab 8, page 12 on Opus. And that would be page 107 in the hard copy bundles. So the judge is making the point here that in October 2019, about 6 months after Mr. Gibson's account was closed, 3.4.1 was, in his words, effectively rewritten. And you can see the rewritten rule there, the indented paragraph. So the wording of the new 3.4.1 sub 1 is focused on the interactions between the licensee and the customer. You must interact with the customer in a way which minimises the risk of them experiencing harms associated with gambling. You must identify customers who may be at risk of experiencing harms. You must interact with customers who may be at risk of experiencing harms. It's framed in a very different way. It's moved on from policies and procedures and saying to operators, you have to interact in a particular way. Now, as to how they do that, well, there's some detailed guidance, and so we can see from subparagraph 2, licensees must take into account the Commission guidance on customer interaction. Now, my learned friend took you to three iterations of the Gambling Commission guidance on customer interaction yesterday. I'd like to look briefly at all three of those. So the first is the February 2018 guidance. This is in Supplementary Bundle 3, tab 4, page 1, or page 131 in the hard copy bundles. And the key point here is that this guidance, so this is February 2018, this is during the time of the claimant's account, albeit towards the end of the relevant time period, but it's not binding on operators. It's not incorporated into the LCCP. It was only in October 2019, by the new 3.4.1 sub 2, that operators became required to comply with the Commission's guidance. So it's fair to acknowledge by this point in time in February 2018, the regulator was urging operators to do it more. They were saying, we would like you to interact effectively. But they didn't change, and they hadn't changed the provisions of the code at this point in time. And if you see from paragraph, look at paragraph 2.4, which is on this page. If I just read that out, it says, as the industry continues to trial and evaluate new approaches to protecting customers who are at risk of harm as new research is published, we will update this guidance. And we expect that to continue to raise standards, we will need to change the LCCP. And it said we will use the evidence of good practice to set these minimum standards. So the next version of this guidance is at the next tab 5. So page 138 in the hard copy bundles, SB 35.
Well, the impression one has is that the gap, this is what, February 2018?
2018, yes.
Even that, at this stage, the Gambling Commission is still, as it were, feeling its way
Quite.
as to how to deal with problem gambling and how to identify problem gamblers. So that, which in a sense emphasises that if the Gambling Commission is still feeling its way, then one can't really be over prescriptive as to what particular operators should be doing.
Exactly, and actually what's interesting is even the newly revised provision, which is quoted at 38 of the judgment, this does not use the word problem gambling or problem gambler or give a definition. So even in terms of defining those terms, the Gambling Commission doesn't reach a landing point. But what it does is it creates more detailed and prescriptive guidance to operators through a fairly dynamic process, it seems, of regulation of what works, what are you doing, we will evaluate those, we will help use that information to help set our new standards. And that helps them produce this guidance, which will be more prescriptive as to the types of behaviours you should look for and how you might look for them, but doesn't define what is a problem gambler.
So does problem gambler and problem gambling then disappear from the Social Responsibility Code in 2019 altogether? And it does in 3.4.1 and is replaced with the concept of harms associated with gambling.
I think
does it disappear elsewhere in the Social Responsibility Code?
If I can, I will come back with a clear answer on that, just to be absolutely sure. But I'll certainly looking at that provision. It does seem almost to be an acknowledgement that term isn't necessarily particularly helpful, and it is a shift in focus towards looking at particular behaviours rather than focusing on.
And a shift in focus in terms of achieving a result.
Yeah.
It must interact in a way which in fact minimises the risk of experiencing harms. So it becomes an obligation to achieve a result.
Yes. And as I say, the Gambling Commission does become more prescriptive at this point in time, because the guidance we have on screen now, so this is published in July 2019 but came into effect in October 2019. You can see it has the word formal at the top. That reflects the fact that it has a different status.
So this is now, at this stage, is after the end of the relationship?
Exactly. So, well, it was, yes, so it's published in July 2019 after the end of the relationship. It came into effect in October 2019. So by this stage, I say this isn't relevant to the construction of old 3.4.1 at all. And in fact, it works the other way, because what we can see here is how things have changed. And then just to complete the point, the third version of the customer interaction guidance that you were taken to yesterday is in supplemental bundle tab 3.
Page
158, yes, so it's tab 8. So supplementary bundle 381, yes, or page 158 in the hard copy bundles. And this was published in June 2022 and came into force in September 2022.
Yeah. And
it's even more detailed. So you can see the Gambling Commission through, now it has the hook under the new 3.4.12, say that licensees must take into account the guidance issued by the Commission on a customer interaction. It then has greater leeway to publish new guidance, and in that way to be more prescriptive or to change what it's requiring. But this is all after Mr. Gibson's account has been closed.
And the concept of problem gambling is replaced essentially with the concept of harmful gambling, which one sees in the 2019 guidance, which may not be any easier to
a different
deal with.
problem.
But anyway, there we are.
Fortunately, we don't have to decide that point.
No. So those are my submissions on 3.4.1 and what it means, and we say that the judge was right to say that it is a relatively undemanding non-prescriptive provision, and that what is required was for Betfair to have and put into effect policies and procedures, and it certainly didn't contain a de minimis requirement to close someone's account if they were, or if an operator knew or ought to have known that they were a great problem gambler. So I now turn to the submissions, the sort of factual submissions, on whether Betfair whether the judge was right to find that Betfair was not in breach of SRC 3.4.1. And to aid my submissions on this, there is a hand up in the form of a table.
Did we have that was on our desk? Was it?
It may have been. I have provided, I should say, Missouri has very helpfully provided an updated version which also adds references to the hard copy bundles, because the references on that table are only to Opus. So if I hand this version up, it may be a little more helpful. So just to explain what this document is,
Thank you.
Yeah, okay, that's helpful.
So in the first column, points of fact, you see listed out as numbers 1 through to 15, various points of fact that are relevant to the issues on breach. The first 4, so 1 to 4, go to the claimant's alleged breaches, the breaches that the claimant alleges in relation to Betfair's policies and procedures. And the facts 5 through to 15 really go to constructive knowledge and their argument and breach in relation to that.
Yeah.
And the next column along is the key references from the judgment, where we say the judge addressed that point. And the final column is key references to the evidence.
Yeah.
So there are 2 limitations to this document. The first is that it was drafted by reference to the claimant's skeleton argument, and so I'll be tweaking it as we go and reordering the points slightly to respond to how the case was put yesterday. And secondly, just to be clear, the key references are just key references. So the judge had a lot more documents, a lot more evidence before it than this table does justice. But it's just to give your lordships a sense of some of the key documents that we say are relevant to these particularly important facts. So starting with the so-called policy breaches, the judge's overall conclusion on this aspect, as recorded at 130 of his judgment, was that Betfair's obligation was to have appropriate policies in place, and that it did. And similarly, at paragraph 134, the judge said that he was satisfied that Betfair had appropriate policies in place and applied them, and he said he found Betfair's evidence on this to be compelling and clear. And underlying that headline finding, as your lordships will have seen, under the heading compliance in his judgment, which runs from paragraphs 48 to 74, there is a very detailed review by the judge of Betfair's policies and procedures.
Yeah.
So the first point on my table I don't think I need to go to. It's common ground that Betfair did have policies and procedures for responsible gambling. The arguments that the claimants raise on this appeal are in fact much more granular. And before I turn to the detail of those, I do have 2 headline points. And the first headline point is that, as you'll have gathered from my submissions on the proper construction of 3.4.1, we don't accept that the claimant's arguments in relation to the policies and procedures, even if made out, would constitute a breach of 3.4.1 because it was a non-prescriptive provision, which left it to the operators to decide how to do the detail of their policies. And as long as those policies included the matters listed out in subparagraphs A to E, they were not in breach of 3.4.1. My second point is that there is a causation issue here, at least insofar as concerns the claimant's negligence case. I say it's not enough for the claimant to say, well, this aspect of your policy wasn't very good or could have been better. If you'd designed your algorithm a bit differently, that would have been more effective. Or if you'd carried out your interaction differently, then or defined problem gamblers in your assurance statement differently, then that would have been compliant with 3.4.1. Because unless they can show that that breach of 3.4.1 actually had an impact on the claimant, in other words, that but for that breach, we would have closed his account, then as a matter of causation, the alleged breach in relation to the policy doesn't help them. So that's in a sense a preliminary causation issue before you get to the causation issue on the appeal of, well, what Mr. Gibson has done anyway if his account had been closed. So as to the specific arguments that were raised in respect of Betfair's policies and procedures, I think the first point was taken yesterday is actually point 4 in my table. So if we can turn over to the page 2 of that. This is the point about refusal of service.
Yeah.
And my learned friend's first argument was to say that Betfair's policies and procedures don't include anything about refusing service. I think what emerged in the afternoon is what he meant by that was that although Betfair's policies and procedures provided for suspension of a customer account, they didn't provide for exclusion for a permanent refusal, and refusal of service means exclusion. So it's a fairly narrow point, and I should say that I don't accept that refusal of service only means exclusion. If you suspend someone's account, then you are, for the period of suspension, refusing to provide your services to them. But in any event, Betfair's policies and procedures did envisage exclusion as well as suspension. There are lots of documents. There are 3 referred to in the table. The one I would like to take you to in particular is SB13, so the 2015 RG policy. So that's Supplementary Bundle 1, tab 3, tab 3, and it's page 16 in the hard copy bundles.
What's the page number? This is the 2015 policy.
It's
It's
the-
page 16 of our bundle.
Yes, the April 2015 policy, so page 16 in the hard copy bundles. I should say, although it says draft at the top, the judge accepted that policies that were marked draft were in fact implemented at the relevant time.
Yeah.
There's no challenge to that finding on appeal. So if we could turn over to internal page 77, which is page 22. So 7 for Opus, 22 for those using the hard copy bundles.
Yep.
I want to look at this diagram, and I appreciate it's quite difficult to read, but this is a flow diagram essentially explaining how the process will work. And it starts with the account being identified with social responsibility concerns and being sent to Responsible Gambling. Responsible Gambling team investigate, record the details, collate information, create a summary and suggested action. We then branch off because the person who conducts the responsible gambling interaction will depends on whether the customer is a VIP customer or not. So if they have a relationship manager, then you go down the left branch. And if they don't, then it goes down the right-hand branch. And so the responsible gambling interaction is then undertaken either by the account manager, if it's a VIP customer, or by responsible gambling or help desk if it's not. And then we come back into the middle to the rectangle. Action taken recorded by the responsible gambling team on the case management system and in the customer interaction log. Account is reviewed and identified if further action is required. And then the little diamond, responsible gambling confirmed final recommendation for account. And then in brackets, it explains what those final recommendations might be. No further action, ongoing monitoring required, or high risk exclusion recommended. And then to send the final recommendation to Operations Director, TBC role responsible. And then you can see underneath there are 3 options. So option 1 is no further action. Option 2, ongoing monitoring. option 3, high risk exclusion recommended. So that word exclusion explicitly appears in the policy.
And the very bottom says exclusion enforced,
Yes.
Which does suggest that in certain circumstances there'll be complete refusal.
Exactly.
Yeah.
And if we could turn over the page, so to internal page 9 on Opus, page 24 in the bundle. We looked at paragraph 4.3 yesterday. So one of the circumstances, sorry, we should start on page 8, so the page before this.
Yeah.
So this is a section of the policy, and it says this contains some examples of the kinds of behaviour which will result in refusal or restriction of service, or where customer interaction will be initiated. These are just examples. It doesn't purport to be exhaustive. And then paragraph 4.3, over the page. And one of the examples was where a member of staff suspects that a customer may not be in a position to make informed decisions about their gambling, possibly due to mental impairment or drug or alcohol use. And there are some examples given of what this might be, one of which is an admission from the customer that they only have a bet when they drink. And you can see that Betfair staff will escalate to responsible gambling team or help desk, if appropriate, suspend the customer's account. And then it says what the responsible gambling team or the help desk duty manager will do. And the third bullet point down is apply timeout or exclusion, if appropriate.
Yeah.
And then 4.4 is the example of where a customer indicates monetary loss that they have not budgeted, or where gambling concerns arise from a customer indicating that they have been spending more time.
Sorry, forgive
Yes.
me, can we just go back to 4.3?
Yes.
I mean, I see the third bullet point says apply a timeout or exclusion if appropriate. Do you have to read that with the words at the end that say ensure the self-exclusion checklist is complete for consent, brackets, if exclusions apply?
Gosh, well that's not a point that I think I can really help you with, and it's not a point that we have any evidence on. So I think the highest I could put it is not entirely clear. But we did see from the diagram that we were looking at earlier, there is a reference to exclusion without that qualification of self-exclusion. And actually, yes, and the point I'm about to take you to next, in relation to 4.4, so this is another example of the kinds of behaviour which will result in refusal or restriction of service. And if we turn over the page to the possible actions, the final bullet point is apply exclusion if appropriate. And there's no reference to self-exclusion.
No.
I would also like you to take you to a short extract from the cross-examination of Miss Susan Lawson, the former head of responsible gambling, who the judge found to be a particularly impressive witness. So that's Supplementary Bundle 6, tab 5, page 97 for Opus, page 830 in the hard copy bundles. So this is yes.
Page 830, you gave the right hard copy.
Yes, so sorry, that's my fault. I gave the wrong reference for Opus. It should be page 32 for Opus. And it's page 830 in the hard copy bundles. Are we all in the same place?
Lines 13 and 14, is it? If the player confirmed those suspicions, we would close. Is that the
Yes.
message you're relying on?
And then there is also the RGI script, which is in supplementary bundle 4821 by Birss, and page 322 of the hard copy bundles. So this is the script for RGI outbound calls. It's appended to the witness statement of Mr. Noel O'Keefe because it was Mr. Noel O'Keefe who developed it and who gave evidence about it at trial. And so the second paragraph is relevant. It explains that it's important on the court to listen to the customer, both in what they're saying and how they are saying it. A customer may answer that they're comfortable but sound doubtful or hesitant, in which case we would probe a little further. And then if you turn to the final two paragraphs, the point I'm making in relation to those is that they would add a minimum of 6 months closure, but also offer extended timeframes, 1, 3, 5 and permanent. So closure and exclusion, not just suspension, were envisaged by the policies. And there's a connected point, which is that my learned friend says, I think this was his third point, well, which is a slightly different point, which says, well, even if your policies did envisage suspension and exclusion, they weren't very good policies, because ultimately, if a customer said they were happy and comfortable, then that would be the end of the inquiry. Now, I say if that is all that our policies and procedures did, that's sufficient for SRC 3.4.1. But in any event, that is not a fair reflection of what their policies and procedures envisage. And you can see that in a sense from what we've just been looking at the top of the script. You must listen to what the customer says and how they're saying it. If they're sounding doubtful or they hesitate, then you probe further. So it's not just a tick box exercise of saying to the customer, are you comfortable? And if they say yes, that's the end of it. And there are some further references in the table to the evidence there of Mr. O'Keefe and Ms. Clines and Ms. Lawson, who all essentially confirmed the same point, that it wasn't as black and white as my learned friend suggests, and that they would, in certain circumstances, refuse service to a customer, even if that was against the customer's wishes.
Yeah.
So the second alleged breach in relation to Betfair's policies and procedures was that Betfair's policy, and I'll be careful how I say this. So the point was put that Betfair's policies involved the designation of a problem gambler as limited to a person who had self-excluded and later as someone who had registered with GamStop, and that is deficient. Now I confess my understanding of this point had been was that it was a criticism of the customer activity interaction programme. So that's point 2 on my table. To the extent that that point is maintained by the claimants, it's wrong for the reasons the judge gave there and for the underlying evidence. But I think what emerged yesterday was a slightly different point relating to the public assurance statement. So if I can take you to that now. This is in supplemental bundle 8, which is the confidential bundle, tab 17. Now, although this is in the confidential bundle, the passages I'm going to take you to are not confidential, so we can have them up on the screen. So it's supplemental bundle tab 8, supplemental bundle 8, tab 17, and it's page 1946 in the hard copy bundle is where it starts. And just in terms of what this document is, and it's an assurance statement made by Paddy Power Betfair to the Gambling Commission. Not all operators are required to submit such statements, it's only the largest operators. And again, it's just another part of the regulatory regime, this additional sort of reporting requirement. So this is Paddy Power Betfair providing information to the Gambling Commission. And I say it's a rather unpromising start to an allegation that Betfair was in breach of the LCCP, that it was in breach by reason of doing something that it said in terms to its own regulator, in its public assurance statement, which is the point that was made yesterday. So the relevant passage is at page 24 on Opus, 1946. 1969 in the hard copy bundle. And so you can see that the question that's being asked of Paddy Power Betfair is, what is the current prevalence of AR/PG within your customer base, and how do you identify it? How has this changed since your last assurance statement? So AR stands for at risk, and PG stands for problem gamblers. So what Paddy Power Betfair are being asked is not how do you define problem gambler for the purposes of your policies and procedures? What is a problem gambler for the purposes of your interactions? It's saying in terms of your customer data, how many of these people do you have? And in that context, you can see that the definition that Paddy Power Betfair uses, first of at-risk customers, which it defines by reference to its own internal CAP predictive modelling system. And then the point that the claimants take issue with, which is that they define problem gamblers as those who have self-excluded and gone on to register with full stop. And what that leads to over the page, so Opus page 26, hard copy 1971, is that it says Paddy Power Betfair has calculated that the revenue from at-risk customers is 7.2%, and the revenue from problem gamblers is 0%. But the claimants say, well, that's ridiculous, that's a terrible definition of problem gambler and it's a breach of the code. But the point here is that what this document is doing is it's not setting policies and procedures, it's not saying we're only going to interact with people who meet this definition of problem gambler. And there was evidence on this at trial from Ms. Lawson, and what she explained was that when you're doing this kind of assurance statement, you need to be very clear. You don't want to mislead the Gambling Commission as to the prevalence of problem gamblers. And so what you do is very transparently say, we're going to adopt this particular definition, and then you can follow it through and give accurate information. And Ms. Lawson's evidence on that, we don't need to turn to it. It's supplemental bundle 6, 517, page 815 in the hard copy. And I do say as a side point here that it's interesting that even at this time, 2018, Paddy Power Betfair was saying to the Gambling Commission, we're not really sure how to accurately define problem gamblers and to tell you how many of them we have in our customer base, so we're going to adopt this narrow definition. And there's nothing to suggest that the Gambling Commission come back and say, well, hang on, isn't it obvious it's customers who are spending more than they can afford, or it's PGSI. So the next policy...
Just going back to the
yeah.
slightly ambiguous bit in the policy under 4.3 about exclusion if appropriate, but then ending with saying ensuring that the self-exclusion checklist is completed and sent to the relevant duty manager if exclusion is applied. That might suggest that if exclusion is compulsory applied, nevertheless it's the self-exclusion form that is used to inform the duty manager, and that's how it'll be recorded as a self-exclusion.
Possibly.
Well, there wasn't any evidence that that was so.
No, I don't believe so, no.
Which, if it is right, would mean that using the figures recorded under self-exclusion would be a perfectly sensible way of doing it. But no evidence on that. Yeah.
Mm.
So the next alleged policy breach in the claimant's closing argument related to the Betfair's risk calculator, that's my sub-point 3. We didn't hear anything on that yesterday, so I'll just limit myself to 2 points, which is to say that there's no requirement to have a risk calculator or to set by any particular metrics, and also that the judge accepted Betfair's witness evidence that the calculator...
You referred to the witness evidence that dealt with that.
And so the final point under this heading, and I'll take it briefly, isn't on the table because it was a point that was raised already yesterday, which was to say that your system doesn't allow the responsible gambling assessor to see all relevant information in one place, and that makes it a deficient system. So the short point is that 3.4.1, there's nothing in 3.4.1 which says that your responsible gambling team must share all information, or your AML team must pass on all information to responsible gambling team. And if that was so required, the Gambling Commission would have said so. There was also evidence at trial from Betfair's industry expert, which isn't in the bundle, but we can provide it if it's helpful, from David Clifton. And he said even as a matter of industry practice, it's industry standard, it wasn't clear or expected for operators to pass on all information from AML to responsible gambling.
No.
So I've looked up the escalation policy. I can see that there is some information provided between the parties, that they don't work in silos. That seems to me to be perfectly good. There was a connected point raised here, which is that it was said that the judge made a mistake because he confused AML and responsible gambling. He sort of said that they were synonymous. And I'd just like to go briefly to paragraph 80 in the judgment. So that's back in core bundle at 8. And this is where the judge says that in his view it's impossible to separate AML requests for responsible gambling interactions. Now, I don't read what the judge is saying there as saying that they are one and the same thing, if that's the submission that's being, but what he's saying is that they're closely connected. And in fact, it was the claimant's position at trial that information that he provided to the AML team about his resources and about the fact that he was selling properties, that that was relevant to the responsible gambling analysis. And the judge explains why they are so closely connected, paragraph 18. So there's no error in his analysis there. And finally, in relation to the case of Deere and the public statement, which was the sort of final point on public policy and procedure breaches, alleged policy and procedure breaches, I think my learned friend accepted that by reason of the Hollington and Hewthorne rule, those materials don't really help him anyway. Just to be clear, the Deere case concerned a retail customer of Paddy Power before Paddy Power and Betfair had merged.
No.
So it was a different customer, different entity, and different context. And in relation to public statement, I say that it refers to 5 customers of any home.
Well, the short answer to all this is none of it related to Mr. Gibson. Full stop.
Exactly. So if I can turn then to the second group, the second point in terms of breach, which is the allegation that Betfair should have closed its account sooner and that they were in breach of 3.4.1 not to do so. The short answer to this has already been canvassed, which is that it was no requirement of SRC 3.4.1 to close a customer's account, even if they were likely to be a problem gambler. That's just not what it says. But although, in a sense, that's the beginning and the end of it for 3.4.1 and ground 1, we do also say that there was no error in the judge's underlying finding that Betfair was not aware and cannot be taken to have known about Mr. Gibson's gambling problem. And it is important to spend some time on this because the same or a very connected point arises in relation to the ground 2 duty of care. Because it said that because Betfair knew or ought to have known of the gambling problem, that's why on the facts a duty of care arose.
Yeah.
And in my table, you'll see what I have tried to do is separate out. So the first section, which starts at sub 5, are the facts going to actual or constructive knowledge, the judge's core findings. And this, the points of 5 through to 8 are the points that Mr Davies-Jones took you to earlier, arising from paragraph 129 of the judgment. So Mr Gibson kept his gambling to himself, could afford his losses, took steps to actively hide his gambling problem, told Betfair he was comfortable, and the fact that it's very difficult to identify a problem gambler, particularly one who's not being honest. And then the points that follow are the specific points that the claimants raise on appeal. Now, starting with the points of 5 to 8 in the table, the claimant does not, save perhaps to a debate about what affordability means, challenge these findings. But they also cannot ignore them either. And I think it is important to spend a little bit of time on them, because there was compelling evidence in relation to each of these 4 statements of the judge. And although they're expressed shortly in the judgment, paragraph 129, they are very weighty considerations on the question of constructive knowledge. So before one starts island hopping and looking at particular items or facts which are said to have alleged to put Betfair on notice that the claimant was a problem gambler, it's important to have a good sense of what these findings were and the evidence that underlay them. So the first finding, I think what I'll do, I'm conscious of the time, if I just do the first one now because the second one is a bit more involved. But the first finding that the claimant kept his gambling to himself. That said at paragraph 129 in the judgment, the same point at paragraph 15, where he said that the claimant himself accepted more than once that if he had a gambling problem at all, he kept that to himself. And the claimant did lead some evidence that he told others about his gambling problem, or that about his losses, but the judge rejected that evidence as untruthful. So that may be a convenient place to pause.
How are we doing? Time?
Mr. Duke and I will obviously have to cut our cloth to meet the time available.
Well, I'm only saying that because we can't sit beyond 4:15.
I'm grateful. Well, if I aim to finish by 5 to 4, would that be acceptable?
Yeah. Right. Okay. Right, 2 o'clock, please.
Court rise in favour.